Well, hey there, Bill O'Leary coming to you today to answer the question, what are estate planning transfer costs? It's a question I get from time to time. So hopefully I'll be able to give you some clarity on that. Real quick, let me introduce myself to you. Again, named Bill O'Leary. My law firm is Legacy Planning Law Group. So I'm an attorney. We're located in Jacksonville, Florida. And we focus on three specific areas: estate planning, trusts and states and wills and that sort of thing, elder law, okay, protecting assets for seniors, and then probate and estate and trust administration. So we focus on just those areas. So let's jump right into the topic at hand. Estate planning, if you will, transfer costs. What does that mean? Well, I think it really refers to two things. One, the cost of administering or settling an estate after someone dies, number one. And then number two, the cost of taxes that might be imposed when you die. So the first cost, the estate administration cost, So there is a cost to administering or settling an estate. Dying is not free. So aside from the grief and the pain that accompanies the loss of a loved one, there is a cost that accompanies death, a cost that is unavoidable. And so this is a cost to basically close out an estate. Now, this cost can be a lot, or it can be not so much. So the cost can be a lot if the deceased loved one did not plan well and the family finds itself stuck in the probate court. Probate, what is it? It's a court process. It's a court process where your estate is administered with the oversight of a probate judge. Now, why is this such a big deal? Well, aside from how long a probate takes, and by the way, in my experience, the average length is between 9 and 15 months. And if we have a probate matter that falls outside of that sort of that general range, it's almost invariably at the higher end. It rarely is less than 9 months. So it takes a long time. And the second problem is it's quite expensive. The largest expense usually involves the attorney's fee. And the reason is that an attorney, at least in the state of Florida, is required to handle a probate, and most every probate, required to represent the executor. So the executor, again, is required to hire a lawyer. And so how does the lawyer get paid? So the fee under the statute, it can be tied to a percentage of the value of the estate, between 3 and 5% as a fee that goes to a lawyer. Ouch, that can make it quite expensive. So is it possible then to substantially reduce the cost of administering an estate? And the answer is yes, by planning ahead to make sure that your family doesn't get bogged down in the probate court. There are ways to do it. And a very common way to do it is by putting in place what's called a living trust. And a living trust basically is a substitute for a will. The planning that we provide focuses on setting up a client's affairs so that things pass smoothly and easily to their loved ones after they die or after they become incapacitated. So their assets will go to their family outside of probate. And many of our clients see the wisdom of using a living trust to do that. So that's the first sort of transfer tax cost, administering the estate. Second, taxes. Let's talk about that. There are two types of taxes that heirs may have to pay. One is something called a transfer tax, and the second is income tax. Focus on transfer tax. A transfer tax is a tax on the transfer of money or assets or property that you transfer for nothing in return. So it's not like you're taking money and paying for a particular good or for a service rendered. You're just giving it away for free. And so transfer taxes focuses on two types of giving. One, giving while you are still alive. That might be subject to a gift tax. And then two, giving away at your death. That might be subject to an estate tax. Gift tax and estate tax together are referred to as transfer taxes. So how does the tax work? Imagine this. When you're born, you're in the hospital room, and in walks Uncle Sam. He's all decked out, got the hat and so forth, and he hands the infant a coupon. And that coupon says this: congratulations, the U.S. government now gives you the ability to transfer away a certain amount of money. And as long as the amount that you transfer away is less than that coupon amount, then you don't have to worry about these transfer taxes. Okay. And so imagine that there's sort of two buckets that are sort of counted up after you die. Number one, the bucket that consists of assets or money or property you gave away while you were still alive. And number two, the second bucket, money, assets, etc., that you gave away at your death. Add those two buckets together. And if the total number of those two buckets is less than the coupon amount, then the estate does not have to worry about paying in estate tax. Right now, that coupon amount is quite high. In fact, it's almost $11 million per person, almost 12 million, in fact, here in 2022. And if you're a married couple, you can multiply that by 2. So typically, there is no estate tax that's due with a married couple at the first spouse's death. Those are transfer taxes. The second kind of tax are what are called income taxes. Why might an heir have to pay income tax? Well, a classic example, the deceased loved one had an IRA account, okay? And they named beneficiary of that IRA. Let's say parent named the kids. Now the kids inherit the IRA and they have to start taking money out. There's a certain period of time under the tax law during which they have to take the money out. Well, when they do, assuming that the IRA was what's called a traditional IRA that the deceased account owner had, traditional as opposed to a Roth, but most people have traditionals. When the money is taken out, tax has to be paid, okay? So that's income tax that the heirs have to pay. So part of good planning focuses on trying to reduce, if not eliminate, the exposure to transfer taxes and reduce or at least spread out the exposure by the heirs to the income tax. So again, that's the second sort of estate planning transfer cost, taxes. So look, if you'd like to know a little bit more about this area, estate planning transfer costs, and maybe how we can help, we would really love to talk to you. And so to make it easy for you, an easy first step, we encourage you to go ahead and schedule a phone call with us, a 15-minute free phone call that we like to dub our discovery phone call, where basically you can tell us what's on your mind, what you're looking to do, what your concerns are. And that way we can, again, sort of start a conversation. We can also see if we'd be a good fit for each other. And to make it really easy, what we would encourage you to do is just book the phone call with us. Go to our website, legacyplanninglawgroup.com. Right on the homepage is a book your free call button now. Just click on that. Takes you straight to our booking page. Just pick the day and time that works for you. There are a number of options. And then we'll take it from there and we'll get on the call at the appointed time. So Bill O'Leary signing off for now. And I would ask you to make it a great day, but better yet, make it a better world. See you next time.